This information is for those facing suit by a debt buyer. It's legal information, not legal advice. Every case is different. You're watching this because you've likely received a warrant debt, or you're concerned about being sued for a debt. Take a deep breath. Let's walk through this together. If you know the rules of the game and the court process, I think it's going to be a lot easier for you.
Once a company has bought your debt, whether the information is accurate or not, they are going to try to collect on it. And they can either do that themselves or assign it to a collection agency. And while many collectors work within the bounds of the law, some behave like this.
James, give me my money back. I want my money, or else I'll kill you.
You want to be a man, or you want to hide behind the telephone like a little bitty mouse? We're going to have your dog arrested if you ever again.
Whoa! Whoa! That is not just horrifying, it's stupid.
Debt collection has become a hot-button issue, easy to make fun of and easy to report on, but many of these reports offer nothing in the way of solutions. So I went and searched for ways to do so, and got help from Lynchburg Legal Aid.
Yeah, it's actually a really bad practice because they buy the debt at a very low amount.
Staff attorney Erica Nosable, and she walked us through the starting process of handling a debt collection case. Let's start out with some definitions.
So the plaintiff is the person who says you owe money. It can be a person or it can be a company. The defendant is the person who's being sued. So in this case, that would be you.
So what does this area under claim mean?
So that's a good question. So the area under claim is where you will find the information that they're saying is the legal basis for the amount that you owe.
Now this is where things get weird. The person you are paying for the debt is not actually the person you owe. You accumulated debt of some sort from a bank or medical institution, among many others. This institution has a lot of debtors to deal with, so they will package your debt up with these many others and offer it to the highest bidder. A debt buyer is an organization that buys the bulk debt at a much lower price than the debt originally called for, and hounds you so they can collect on the full amount.
A government report actually says that the debt collector pays only 4 cents for every dollar they say you owe. So if it's a $5,000 debt they're saying that you owe, they only pay $200 for that debt. And now they're trying to collect what they say you owe is $5,000. So it's a lot more.
So what do we do now?
Well, you've got a couple options. The first is, you can stay at home and do nothing, sit on the couch and just forget about it completely. But that's dangerous because if you don't show up to court, they can get a default judgment. That's an automatic, yes, you owe this amount because you didn't show up to fight it. And that's going to show up on your credit report. And then they can start collection actions, for example, through a garnishment.
So how can I do that?
Well, it's important that we talk about, a couple things that have to happen. So you have to go to court. That's the most important takeaway. It's important that you're early to court. Look ahead online, make sure you know where the courthouse is, and appear ahead of time. So once you know where the courthouse is, you'll go to court, make sure you get there early enough to find parking. There's going to be a lot of people trying to appear on that day. You'll find parking, park your car, and then try to find the right courtroom. On your document, you should be able to see what courtroom that you're in. If you're confused, make sure you ask the clerk or the sheriff who are there at the door, and they'll assist you to get to the right place. There will be several people in the courthouse, so just sit and wait until they call your name. So you'll go before the judge, and you'll tell the judge that you dispute the amount owed.
So I'll say, no, I don't owe the money?
You can simply tell the judge, I dispute the amount owed. I dispute owing the debt buyer LVNV. And after you tell the judge that, you can also ask for a more detailed statement of what the debt buyer is saying that you owe. So this is called the Bill of Particulars.
What is that?
So it's just a request for a more specific statement of what you owe and how you came to owe it. The court will also ask you to respond with what they call a grounds of defense. So this is your opportunity to explain why you believe you do not owe the money. So that will be the first time that you appear. And then once you appear and ask for the Bill of Particulars and the grounds of defense, the judge will then schedule you for a new hearing. So 2 times total. And if you need any information on how to prepare your grounds of defense for trial, that can be found in our debt buyer materials.
Where can I find those?
So you can go to our website at www.blas.org, and there you will be able to find more information about how to write your grounds of defense to prepare for trial.
So that's it. It's all about simply showing up and making your case. As Erica mentioned, you can find all the help you need with this on the Virginia Legal Aid website, as well as a lot of other legal resources to help you out. Head over there for more information.